Hello, I'm Dr. Neeraj Nagpal. I'm convener of Medicos Legal Action Group, and today I shall be talking on compensation claims in medical negligence. How much is too much? Consumer movement started in India in late 1980s. Doctors were included under Consumer Protection Act in the act itself. However, there were some issues in this regard, and these were finally clarified in the judgment of VP Shanta and others versus Indian Medical Association by the Honourable Supreme Court in 1995. However, in that judgment, the Supreme Court had made very clear that only outright cases of medical negligence, where amputation of wrong limb has been done, where a swab or a scissors has been left in the abdomen during surgery, these are the type of cases which would be taken under Consumer Protection Act by consumer courts, and cases which required evidence of experts would still be referred to civil courts for appropriate relief. Over the years, however, we find highly complicated cases, whether ventilation was needed or not, whether coronary artery bypass graft was to be done or a stent was to be placed, why peritoneal lavage was not done, variceal band ligation versus sclerotherapy, what should have been the modality of treatment, video conferencing with experts abroad. All these things have been done in cases under Consumer Protection Act in various courts and commissions. Our issue has been now with the quantum of compensation, which suddenly has become important in the latest judgment which has been given by Supreme Court in a case where a Calcutta hospital has been penalized somewhere to the tune of 11.6 crores. This has caused a bit anxiety among doctors in India, and rightly so. If we look at the statistics, in cities like Chandigarh, as per the National Consumer Dispute Redressal Commission data, 56 cases have been filed for every 1,000 population. When we study the journals on various judgments, we see nearly 15% of all cases being filed in consumer courts are against medical professionals. This is a huge number. When we compare other professionals, lawyers, they are not covered under Consumer Protection Act as of date because there is a stay on the applicability of Consumer Protection Act against lawyers given by this Honourable Supreme Court. Now, for a compensation to be awarded, patient should be a consumer, negligence should be proven, damage should have occurred, and damage should have been caused by negligence. Our problem is, in cases of medical negligence, even patients who have not made any payment, they remain consumers. Patients in government hospitals where they have been treated totally free of cost still remain consumers under the Act, because some patients in the same government hospitals are paying for their treatment. Patients in ESI hospital receiving free treatment still remain consumers. Frivolous complaint people make, and the maximum penalty under the Act is sum of rupees 10,000 only. In this particular judgment, where 11.6 crores has been awarded, it has caused a lot of anxiety among doctors, and rightly so. The hospital has been penalized the maximum. Individual doctors have been given awards of somewhere around 37 lakhs each. When we compare these negligence cases against Motor Accident Claim Tribunal, where also the multiplier method is used to calculate compensation in cases of death. Recently, there have been some judgments, even in Motor Accident Claim Tribunal, where compensations of 15 crores has been awarded. Up till this, we always used to feel that if a bus driver, a roadways bus driver, kills 5 people in an accident, the maximum compensation government would award would be some of rupees 2 lakhs, 5 lakhs. But now recently in Motor Accident Claim Tribunal, this has recently been reported in Panchkula. 5 members of a family had died and 15 crore compensation was awarded by the Motor Accident Claim Tribunal. The similarity is that there is no upper limit to the amount of compensation which can be awarded both under CPA as well as Motor Accident Claim Tribunal. My question is 200 crore compensation for a person's life okay? Is 2000 crore okay? Where does it end? And if we look at it, a drunken driver who rashly drives a truck and kills someone, under law is same as a renowned surgeon who is operating to save a patient with intra-abdominal bleeding, who manages to control the bleeding, but while closing accidentally, he leaves a blood-soaked swab in the abdominal cavity. Roadside accident due to negligence of a driver is same in law as a complicated disease like toxic epidermal necrolysis, which anyway has 50% mortality and is being treated well by a dermatologist of repute or by a physician of repute, but unfortunately dies. Here, the person who has died is a person with a disease, whereas in motor accident cases, a person who dies is a normal, healthy individual. But what is the difference between both of them? The difference is the vehicle in the motor accident case is insured for a fixed premium. If it is a Maruti 800, there is a fixed premium for all Maruti 800s. If there is a truck, the premium for insurance, even for the third party insurance, is fixed. Whereas a doctor is insured for a variable premium depending on the amount a doctor wishes to be insured for. So if he insures himself for a sum of say rupees 10 lakhs, his premium would be 3,000 to 5,000. Now with 11.5 crore judgment, if a doctor wants to insure himself against a claim of 11.5 crores, his annual premium will be in the range of 3,45,000 to 5,75,000 depending on whether he is a physician or a surgeon. And there is no guarantee that the next sensational judgment will not award a sum of 2,000 crores. Initially we used to think 1 crore is too high. It will never happen. Now we have 11.6 crores. So how much should doctors insure themselves for? And when doctors are going to insure themselves for such high awards, obviously the cost of medical treatment which they provide is bound to go up, and this will affect healthcare costs across the board. If he has to pay 5,75,000 premium annually, it works out 47,916 monthly, it works out 1,597 daily, and if he is seeing 30 patients a day, he has to charge each patient 53 rupees over and above his regular consultation fee just to make up for this premium he has to pay for an award of 11.5 crores. That means each patient ends up paying 53 rupees over and above what he is regularly paying to see a doctor. And if, God forbid, the doctor doesn't insure himself, then what happens? Then he has to charge 532 rupees per patient at 30 patients per day including Sundays, working every day for the next 20 years, not taking into consideration any interest he has to pay. So this is phenomenal. This is absurd. No doctor today in India is earning the amounts which are needed to either justify such premiums or such compensations. Another major issue here is under Article 21 of the Indian Constitution, there is a protection of life which has been expanded in various judgments to mean healthy life or health of an individual. So it is guaranteed under fundamental rights. Article 14 provides equality to all and protection against discrimination. Now, let us look at the scenario in a hospital emergency. We have such high compensation which have been awarded. This is a resource poor country. Hospital beds, ICU beds, ventilators, dialysis machines, angiography, other high-end investigations and treatment modalities are always in high demand. Once a doctor on duty is put in a position where he has a poor patient and a high net worth individual, both in need of a ventilator, he will now be bound to choose the high net worth individual, keeping in view high compensation claims for them versus low compensation awards for the poor. My question is medical treatment going to be a prerogative of the rich? Because as a doctor, now I have to always look at two patients with a different eye. One is rich, who may ask for crores on compensation. One is poor, where maximum compensation I may have to pay for a mishap would be a few lakhs. So is my treatment to the rich person going to be different from my treatment for the poor person? It is a thought which needs to be considered, and the answers are not easy. However, we have tried to bring out some solution on how high net worth individuals should be compensated. We think same crime cannot have different penalty in law. Life lost due to same negligence cannot lead to different penalty to the perpetrator. Still, the victim who earned in crores deserves to be compensated for loss, which would be different from a financial compensation for a poor man. What we suggest is fix a maximum compensation payable for loss of life due to negligence at whatever figure the government decides, let's say 20 lakhs. Same compensation should then be paid to all victims who lose their lives due to negligence of pilots, drivers, doctors, engineers, architects, hotels, police, hospitals, whether directly by government or under CPF. High net worth individual should receive added compensation for his loss from his life insurance policies, which all individuals should anyway have. Let uniform insurance premium be paid by doctors similar to third party insurance of vehicles. Different specialties would pay different premiums, like Mercedes premium would be more than a Maruti 800's premium. Premium could also depend on type of facility, individual doctor, non-NABH approved hospital, NABH approved hospital, super specialty hospital. Any accident thereafter, whether medical or roadside, would then be compensated by insurers, whether the compensation is 10 lakhs or 100 crores. The government can have an indemnity tax from all doctors for all patients they are seeing, and after that any compensation may be awarded by the government. These are all different modalities with which high net worth individuals may be compensated for their loss without taxing a doctor who then will tax his patients across the board. Already under Consumer Protection Act, medical treatment has been made a commercial transaction. So we also have another option of Arbitration and Conciliation Act 1996. Should doctors and patients now get into an agreement at the start of treatment as to what maximum penalty would be in case of a mishap? This is definitely going to affect the doctor-patient relationship already, which is under a lot of strain. I don't think any of us want it. So in summary, our appeal to the government is amend Consumer Protection Act to remove doctors from within its ambit. Give powers to award compensation to Medical Council of India and state medical councils. As of now, Medical Council of India and state medical councils only have the power to revoke the registration of a doctor. Besides this, they have no other powers either of a judicial magistrate to award imprisonment or of awarding any compensation. Criminal negligence should not be including medical negligence, and protection should be given to doctors under section 87, 88, 89 and 92 of Indian Penal Code for action having been done in good faith. If all this is not feasible, then at least amend the Consumer Protection Act to introduce a cap on compensation which can be claimed, increase penalty for frivolous complaint to 50% of amount of compensation claimed, and follow VP Shanta versus Indian Medical Association judgment of Supreme Court in toto, which said that Consumer Protection Act was only for outright medical negligence cases like amputation for wrong limb, leaving a swab in the abdomen, and any case requiring evidence of experts or complicated medical issues where they are involved, they should be referred to civil courts for appropriate relief. Thank you.